The Maine Human Rights Act, Discrimination, and COVID-19. COVID-19 is a health crisis, but it is also a test of societies, of governments, of communities, and of each and every one of us. In this video, you will learn about the Maine Human Rights Act, find out more about the role of the Maine Human Rights Commission, and, through examples, become aware of how restrictions and measures designed to combat the COVID-19 pandemic could lead to new discrimination issues in Maine. Maine Human Rights Act. The Maine Human Rights Act is Maine's anti-discrimination law. It prohibits discrimination on the basis of protected classes, innate characteristics one generally does not choose about oneself, in employment, housing, places of public accommodation, education, and extension of credit. Protected classes in the Maine Human Rights Act include race, color, ancestry, national origin, sex, sexual orientation, gender identity and expression, physical or mental disability, religion, age, and other categories in certain contexts. It also prohibits retaliation for asserting rights protected under the Act. The Maine Human Rights Commission. The Maine Human Rights Commission is a state agency that interprets and enforces the Maine Human Rights Act in the public interest and enforces the Maine Whistleblowers Protection Act in employment, receives and investigates complaints of discrimination, attempts to resolve conflicts between parties, and provides guidance and education to the public. Quick fact: the Maine Human Rights Commission is a neutral agency. It does not provide assistance or legal advice to any party to a complaint. COVID-19 and discrimination. Measures and restrictions to address the COVID-19 pandemic, such as mask mandates, social distancing guidelines, and business shutdowns, as well as public perception about the virus, could lead to new discrimination issues under the Maine Human Rights Act. Discrimination can be making a decision about whether or not someone can access opportunities because of their protected class characteristics, or failing to make changes to rules that affect them because of their innate characteristics, or not addressing hostility toward them for their membership in a protected class. Following are some examples of how these issues can arise related to COVID-19 in employment, housing, access to public accommodations, and education, about which some employers, providers, landlords, employees, patrons, and tenants should be aware. Employment. Quick fact: the Maine Human Rights Act, in part, makes it unlawful to discriminate in employment based on a person's mental or physical disability, age, religion, sex, color or race, ancestry or national origin, sexual orientation or gender identity, and also prohibits retaliation for asserting rights protected under the Act. Employees should be aware that generally it is okay for employers to have neutral policies that are applied to all employees equally, like requiring employees to report to the workplace in person, wear a mask at work, have their temperature checked before entering work, report being exposed to COVID-19, and get vaccinations. Employers should be aware that it is okay for employees to ask for reasonable accommodations or changes in how policies are applied to them, if necessary because of a disability or other protected class, so long as the request is reasonable, related to the disability or protected class, and not an undue burden or direct threat to health or safety. Consider these examples. This older employee has asked to be moved from a cubicle to an enclosed office with a door because their age makes them extra susceptible to COVID-19. This employee cannot wear a mask at work due to a disability and has asked to work from home instead of at the office. This employee with a hearing disability cannot see through masks to understand work instructions and has asked that their coworkers wear masks with clear plastic around the mouth. Firing these employees or not considering reasonable accommodations based on these examples could lead to possible discrimination complaints to the Maine Human Rights Commission. Housing. Quick fact: the Maine Human Rights Act, in part, makes it unlawful to discriminate or create a hostile environment in housing, at least in part based on a person's race or color, ancestry or national origin, physical or mental disability, sexual orientation or gender identity, religion, sex, familial status, or receipt of public assistance. This landlord knows about, tolerates, and is encouraging an environment in which tenants continually harass a fellow tenant who is perceived to be Asian about the COVID-19 virus having originated in China, and fails to address the hostile environment effectively. This tenant has lost their job because of COVID-19 and is going to be using general assistance and a Section 8 voucher to pay their rent, and has been given notice of eviction because the landlord has a policy against renting to people who receive public assistance benefits. This applicant for rental housing with a heavy African accent and limited English has been told there is no housing available, while another applicant with no accent and fluent English has been told that housing is available. The refusal or termination of tenancy based on the receipt of public assistance and the failure to rectify a hostile environment in these examples could lead to possible discrimination complaints to the Maine Human Rights Commission. Places of public accommodation. Quick fact: places of public accommodation are places or services that are open to the general public, like restaurants, hotels, stores, professional offices, government offices, schools, and other places or entities offering services available to the public. Quick fact: the Maine Human Rights Act, in part, makes it unlawful to discriminate in public accommodations based on physical or mental disability, sex, race or color, sexual orientation or gender identity, religion, or ancestry or national origin. People should be aware that generally it is okay for places of public accommodation to require patrons to wear masks on site, practice social distancing, have their temperature checked before entering, or report being exposed to COVID-19. Providers should be aware that it is okay for patrons to ask for reasonable accommodations to policies, and that the provider must consider whether the request is reasonable and related to the disability or protected class, and not an undue burden or direct threat to health or safety. The provider should also be aware that even if it cannot accommodate the person on site, the provider is still required to make its services available to the patron. Consider these examples. A patron with asthma is shopping in a store without a mask. A store employee approaches the patron, knowing it is okay to ask patrons without masks to leave based on state mandates. However, the patron informs the employee that she cannot wear a mask because of asthma. Without exploring accommodations to make services available to the patron, the employee asks the patron to leave. This person with a compromised immune system, who is very susceptible to COVID-19, needs a prescription, but their hearing loss makes it difficult to use the phone-based system that provides alternative access to the pharmacy's services. This family has been refused accommodations at a hotel because they have 2 children with them, and the staff feels that children are more likely to be COVID-19 carriers. Failing to train employees with a thorough patron communications plan and solutions, considering special accommodations for those with disabilities or susceptibility, or refusing accommodations to children in lodging in these examples could lead to possible discrimination complaints to the Maine Human Rights Commission. Education. Quick fact: the Maine Human Rights Act, in part, makes it unlawful to discriminate in education based on physical or mental disability, sex, sexual orientation or gender identity, national origin, or race. Consider these examples. This parent whose disability makes them highly susceptible to COVID-19 fears being on a school campus for required parent meetings as on-site learning resumes, and has asked to have meetings occur remotely. This student has been suspended from being part of an athletic team because they are not able to wear a mask due to disability, but wants to continue to participate with the team. These international students from Europe have been assigned housing exclusive to fellow Europeans in the belief that they are higher COVID-19 risk to the domestic student body. Failure by an institution of learning to consider reasonable accommodations such as continued online teaching and meetings and alternative roles for student athletes, or segregating students in housing based on national origin, based on these examples, could lead to possible discrimination complaints to the Maine Human Rights Commission. Quick fact: many entities are covered under more than one type of MHRA jurisdiction. For example, a residential school may be an employer, and housing, and a place of public accommodation, and a provider of education. A rehabilitation program or assisted living facility may be a place of public accommodation, and housing, and an employer. The overview and examples in this video are not an exhaustive study of every scenario in which discrimination under the Maine Human Rights Act could be affected by COVID-19 and should not be considered legal advice.
Discrimination has no place in Maine's response to COVID-19.
We must all speak out against unlawful discrimination and promote inclusion and unity.
MHRC will not waver during the COVID-19 pandemic, and we stand ready to assist you during these unprecedented times.
For more information, you can call the Maine Human Rights Commission at 207-624-6290. You can email at info@mhrc.maine.gov. You can visit the Maine Human Rights Commission website at www.maine.gov/MHRC.